Can one of you turn your mic and just do a test real quick?
Can you hear me now?
One more time.
Can you hear me now?
All right, let's go to the Zoom. I was worried for a second.
Good evening and welcome to the Tuesday, December 23rd, 2025 meeting of the Ashland Zoning Board of Appeals being held at Ashland Town Hall in the second floor Select Board Hearing Room. This meeting is being recorded and broadcast live by WACA-TV and live streamed on Facebook. Remote participation is available using the Zoom video conferencing platform for convenience only. Any disruption with the video conferencing platform will result in the platform being shut down. However, the meeting will continue. Meetings will continue to be broadcast on WACA-TV and live streamed on Facebook. To participate remotely on the agenda, there is a link to join the Zoom feed, and there's also a telephone number where you can call in for the feed as well. First order of business is to call the meeting to order. I, John Featherton, present.
Hi, Brian Forrestall, present.
Hi, Ryan Sullivan, present on Zoom.
Hi, Stuart Siegel, I'm present on Zoom.
Excellent. Item number 2 on the agenda is the continued public hearing of 55 West Union Street, a 40B comprehensive permit. I see on the Zoom feed that we have Ms. Sweet, the applicant's representative, and I also believe that Attorney Haverty is maybe present on that as well. I'm seeing a smile, so I guess I got that right. It was my understanding that because we finally have gotten the engineering peer review report that came in late last week, and because of scheduling difficulties that some people may have, that we were going to continue this matter to our first meeting in January, which would be January 13th. Am I correct in that?
Good evening, Mr. Chairman. It's Lynn Sweet from LDS Consulting Group. We came tonight first because we wanted to respond to the letter that was provided last week by your attorney. The other thing that we were hoping to accomplish tonight was to get your permission to create a working group to address the sewer issue, the suggestion that the sewer should be moved to the middle of the road. And so we did want to show you a plan on that and why we feel it's important to try and get a number of people in a room to move that issue forward. We also wanted to give you an update on the mounding analysis. So we don't want to take up a lot of your time, but that's why we're here tonight.
Okay, well, I was under the impression that we were simply going to continue it to the matter until January 13th, but if there's something that you want to address and it's not going to take a lot of time, obviously we haven't received anything in writing from you about any of this, and I understand your desire to respond to the letter that you received from our counsel, Brian Winter, who is sitting here at the table with us. And once again, I neglected to introduce him.
Can I just ask for a couple points of clarification, if you don't mind?
Sure.
So I did email the your planner, basically saying that we did wish to be heard at the meeting, and a couple of matters that we want to address. The other thing is, I just want to check to see if you did receive the response from Attorney Haverty.
So, Mr. Chairman, just for the record, hopefully you guys can see me on Zoom. Brian Winter, I received it, and I believe you CC'd the zoning board as well. Is that correct? And the planner. So that should be in the board's file.
On both of these matters,
Okay.
yes.
Yep.
Yes. So I guess, it's up to Attorney Winter and Attorney Haverty whether they want to talk about the letter. I want to talk about the work, the working group and some progress.
Mr. Chairman,
It's your meeting.
may I make just a statement and maybe a suggestion with respect to the letters that were exchanged between the attorneys?
Please do.
Because I know zoning boards love to hear two attorneys go back and forth on these matters, but I think the important part for the board to know, and the part I'd like the applicant and the applicant's team to hear, is that, it's our job to put a statement like that on the record if we have a concern with respect to our rights under the regulations. Conversely, it's the applicant's job to respond to that, which they did in writing, and say, in sum and substance, and Attorney Haverty can correct me if I'm paraphrasing this inaccurately, but we're not there yet. We haven't gone through all the peer reviews. The regulations require us to complete the peer review, have a colloquy with the applicant about what kind of conditions we're looking at, and the applicant hasn't made a final decision on whether or not to resist that condition or not. So because I believe the public hearing clocks out in mid-February, I can't remember the exact date, I thought it was important to just put that on the record, and they've responded to it, and so maybe we cross that bridge in a few weeks, maybe we don't. But the point is that now it's memorialized on the record, and if we need to circle back to it, both sides are on notice that issue's out there. Now, if the peer review and the discussion goes in a different direction and the issue gets resolved, well, then we don't have to circle back to it. So I think for the time being, there's no action that the board needs to take on it. And that issue is essentially kind of tabled for the meantime. So let me know if any members have any questions on that. And I know Attorney Haverty is here, and if he wanted to state anything about that, or add to anything or correct anything I said, Mr. Chairman, I'd respectfully ask you to invite him to do so when the time's appropriate.
Okay, I guess my thought, what you said, frankly, I don't particularly want to listen to two attorneys talk about something that may not ultimately even be an issue. It's a waste of your time and it's a waste of our time. I understand that the applicant has written an opposition to the letter, which was not surprising. And I would think we could table that discussion until a subsequent meeting. I'm interested to hear about Ms. Sweet's suggestion about a working group, which might help address the issue that we're talking about with the letter that you addressed about the uneconomic issue. So I don't want to overstep with Mr. Haverty. If he wants to say something now about this issue, fine. But my sense, and I will defer to other board members as well, is that we table that discussion until it's necessary. Obviously, the time is going to run out in sometime in February, so that our next meeting is going to be January 13th, and I would anticipate that we're going to have several special meetings as well as our regular meetings on the second and fourth Tuesday of the month to get this matter where we need to get it, unless extensions are granted, and I'm not suggesting they will or they won't be at this point. But fellow board members, what do you think about tabling the discussion between the attorneys on the uneconomic issue?
I'm fine with that.
Same here.
Okay. Attorney Haverty, is that fine with you? Or if you wish to say something, by all means do so. We can't hear you. It's breaking up.
Okay. I have no problems with anything that Attorney Winter stated, so I'm fine with tabling this.
Okay, good. Then why don't we move on to the next issue that Ms. Sweet raised, and that was the working group issue. What do you have on that?
Thank you, Mr. Chairman. So I did want to let you know that as of yesterday, we have engaged another engineering firm. They had the privilege of going out with a member of the DPW last week to look at manholes. So we are going to be having the cameras put through the sewers, as well as trying to catch a rainfall within 30 days. So we're expecting those portions of the sewer review to be completed by the end of January. With regard to moving the sewer, I just wanted to bring up a map, and then I'll give you my suggestion if I'm able to do that. It looks like I'm not allowed to share. Is that possible?
Jasmine is in another room on Zoom, but she's
Oh,
managing
somebody
the
gave me
meeting, so I think
permissions.
she will allow you to do so.
Someone did that. Okay. So I wanted to explain why we're struggling with this and why we think having a working group would be really helpful. And actually, an issue was brought up in the attorney letter that we haven't really talked about, which is why did the project eligibility letter have the sewer running parallel to the street, and why did it end up getting moved at when we came in for the PEL? So this is kind of the Dunkin' Donuts over here, just to kind of orient you. And this is West Union and Memorial. So the issue that we're struggling with, and the reason that it was moved, from what I understand from the engineers, was that the electric line, the water line, and the gas line all run close to on the applicant's side of Memorial Drive. So when they went to do the full engineering and the stormwater management, the concern was if we were to try and put a sewer line parallel, knowing the history of this road and ledge, that any kind of blasting would interfere with the other utilities that are already in the road. So that in fact, there is actually, interestingly enough, a second sewer line over here. I believe there's a second sewer line that serves the Dunkin' Donuts, and most likely that sewer line is going, if this moves forward, to serve 55 West Union. But the line that's being relocated is the line that goes and serves the apartments and everything down by the T station. So this is a portion of an as-built plan that the MBTA did. The other thing is that there is still an MBTA construction easement on the property, and that Memorial Drive was voted to be taken as a public way, but that was never recorded. So I know this is very long-winded, but we feel that it's really, really complicated, and it's really important to get in a room with our engineer, your engineer, and the DPW director and talk amongst ourselves or, the engineers, have them talk amongst themselves to try and peel back the different layers and get some of the history on this, which is, to see what is and isn't practical, and just kind of flush out the different issues, because there is some history here. So
I just
my
wanted to
ask,
be clear about something I thought I heard you say, and I'm not sure I heard it correctly, but that
yeah,
Memorial Drive was voted as a public way, but it was never recorded?
yeah, George Connors, who's with our engineering office. The reason we started looking at this during the Pell is that when we were on the site walk, Mass Housing raised some questions about the status of the road, the status of the easements, and honestly, it had left my mind for a while until I read your attorney's letter, and I'm like, yeah, there was a reason why we moved it, and we haven't had that conversation with you yet. I don't know that that is a problem for what we're trying to talk about. It's probably just cleanup that the town needs to do at some point. It's more all of the other utility lines that are located by the property that if we started to do blasting could be impacted. And that's really the conversation we want to have with your engineers who know the history of this and with your peer reviewer.
Okay, so the people that you would want part of the working group would be your engineering firm and the town's DPW and the town's peer reviewer?
Yes, yes.
And anyone
I
else
think,
that you're
I
proposing?
think the person is Scott, is the person that we talked to at the DPW.
Mm-hmm.
No, again, it's kind of like the legal thing. We don't want to muck up your meeting by going through all of this kind
No,
of
I'm just-
stuff. We
I'm
want to
just-
go and have a conversation and then come back.
Well, speaking for myself, it seems to make sense. If it would help solve a problem, then we should go ahead and explore that.
Okay.
Fellow board members, your thoughts on that?
Can you come back to me?
Okay. Ryan, your thoughts?
I think it's a great idea. The only question I had is whether the MBTA should be invited to the table too. I don't know if that easement you referenced would possibly preclude some route that might be feasible or not. But I know how difficult it is to get them at the table, and if we need to do that sooner rather than later, it'd probably be the best time to do it.
Okay, and Stu, your thoughts?
I tend to agree that a discussion would be helpful. Sharing of information and discovering information is always important to make a valid decision. I don't want to complicate it, but I also want to know how the other entities on Memorial Drive affect this discussion. In other words, it's my understanding that a YMCA building is going to be built on Memorial Drive. How will they hook up their sewer, and is it going to be any different? There's also a possibility that the Arbella project will come to life again on Memorial Drive. How are they affected by this discussion? So it's very important that the town get together and really decide what is happening, because there are a lot of players that are on this roadway.
Okay. Brian, coming back to you.
Yeah, I just had a question about that sewer line. Like, when I looked at the plans, it looks like the sewer line follows the street all the way down to the 55. So all of the other entities that have to tie in, Arbella and Sirius and the Y, will tie in normally to a drain that is in the street like they do on any other construction project. And the only real concern is that this, for whatever reason back in the day, they put the sewer through this property. And that's really the only issue with this particular sewer line, is that for some reason it curves onto the 55 property off of Memorial Drive after everything else is tied in, if I am reading the plan correctly. Can anyone confirm
May
that?
may I correct you if you don't mind?
Yes, I'd love to hear it, yeah.
So, yeah, so, again, you know, this is sewer 101 for me, but there is a second sewer line that is currently serving, the Dunkin' Donuts and will be serving the Y, and hopefully will be serving our property. So that our moving of the sewer line that is currently already on site, that sewer line that kind of zigs through our property today is serving other properties farther down, and not the ones in the immediate area, if that makes sense. So our moving the sewer line is allowed under our easement, just as, you know, an FYI, but does not serve the Dunkin' Donuts and will not serve the Y. And unfortunately, I'm not familiar enough with Arbella to know whether it will impact that. Again, the reason my understanding is why it didn't go along Memorial Drive when it was laid out, third hand from the, you know, the DPW, is that there was too much ledge to you know, get it into Memorial Drive. And that's really why we want to have that conversation. We agree it is very strange that it wasn't laid out, but it sounds like there's some history there in it's actually the conditions of the ledge as to how deep they would have had to go to actually get the sewer line in. So I don't know if that helps in any way.
A little bit it does. Yeah, thank you. So Dunkin' Donuts, the Y, and 55 are all gonna go into a different drain.
Yeah.
And
Yeah.
as far as I know, the only other thing on Memorial Drive is Cirrus.
Well, there's the high school, or, you know, the municipal buildings, and there is Cirrus as well. And I don't know where it kind of goes after those properties, but it's significant enough that it needs to remain
Sure.
viable.
Yeah.
Yeah.
I would think the high school must exit onto 135 from the frontage, not through the athletic fields, but onto Memorial Drive. But again, I'm not a sewer
I don't want to
expert.
speculate.
Yeah.
This is why we want to have the conversation, that
Okay.
it's complicated, and we think it'll move the discussion along. You know, while we're doing the testing in the sewers themselves, we can kind of get a head start on this piece, and you know, hopefully get some more information so that believe me, the client would love nothing more than to comply with the request of the peer reviewer. But there's a lot of trepidation at this moment with just not getting everyone in the same room and trying to really understand the issue and what actually is doable and what's not doable physically.
So do you have any idea when a meeting like this would take place?
We're happy to meet as, you know, right after the first of the year. If I have your permission, and we have actually already been talking with your peer reviewer to make sure we understood the scope that was needed for the sewer investigation, we will reach out to her, and John, our client, can certainly reach out to the DPW, and we'll get something on the books the first week in January if we can.
And I would prefer that you also include our Jasmine in this whole project so that she can be involved on
Yeah,
behalf
and
of
the
the town
other
as
thing
well.
is, the other thing is with working group sessions, if the board feels that they want, they can send a representative or more, as long as there's not a quorum. So that's another option for you. I don't want you to think we're precluding you, as long as we don't violate open meeting law.
Well, in order not to violate an open meeting law, only one member of the board could attend.
What?
But
Okay, that's- I
let's
didn't-
cross that bridge when we get to it. The first order of business will be scheduling the meeting. So,
Okay.
Jasmine, are you okay with that?
Absolutely.
Okay, excellent.
She's here.
She is, she's working remotely.
Oh, I
didn't
thought you
wanna-
said she was at another meeting.
No, she's working remotely. She didn't, she's here in the building at Town Hall, but she didn't want to be in the room for fear that she might spread her cold.
Oh, no.
So we've isolated her, and we've also isolated Attorney Winter down at the end of the tables, so he doesn't also spread it, because Brian and I want to be healthy on Christmas to greet Santa, so there we go. Okay, so the order will be then starting either next week or after the first of the year to get this meeting, working group started. Keep the board advised a time frame, so if one of us wants to attend or can attend, we would have that ability to do so.
Sounds great.
Is that okay with you, Ryan, and you, Stu?
Yes, sir.
Okay, sounds good. Okay, anything else, Ms. Sweet, that you wanted to bring up tonight?
The only other thing is that we are in receipt of the civil peer review, and we're concerned that the civil peer reviewer did not get the last set of plans and documents. So
I
I haven't.
understand you sent Ms. Jasmine an email with that concern, and she was taking it up with the peer reviewer.
Okay.
So that shouldn't
just-
be an issue.
I just didn't know. I guess I was hesitating whether or not. I guess we can say that it was. I guess we can go ahead and respond to it and say that it was addressed in another set of plans. That's probably the most efficient way to do that. So we will try and get that turned around, at least a week before the next meeting, so that we keep that piece going along.
Excellent. That would be helpful.
Okay, that's it. No, we appreciate you giving us a little bit of time tonight and,
Okay.
and
No.
your supporting the working group.
We're making progress, so that's the name of the game, is to make progress, so.
Okay, so the next meeting is on the
January 13th.
oh, you know what? I'm not sure we can be done with the civil in time for that. And you said you meet the 2nd and 4th, so would the next one be the 27th?
It would be.
Okay, so we'll see what we can get done before the 13th and certainly report and then, and know that there's another one
Well-
coming along.
Let me address this issue. If we don't have another meeting until the 27th, that gives us less than 1 month before our deadline, so we need to talk about an extension of time.
We will be happy to grant an extension as long as things keep moving. So,
Okay, we
and
would
I
need-
and I think they are. I
That's
think we're
good.
fine. We at this point we don't have the architectural peer review, but we had a great kickoff meeting on that last week, and we expect that to come along fairly quickly as well. So we'll try and keep up with everything that's given to us, and
I would like something in writing and a date specific on the extension, because again, if we're not going to do anything on the 13th, we need to, and wait to the 27th, that's much too close in time to when the deadline in February is.
I think the deadline is around February 13th or 14th. So our goal would either, to come in on the 13th or the 27th to give you a letter. We just want to make sure things are continuing to move. But we don't want you to feel like,
Well, there's no need to schedule it for the 13th if you're only going to give us a letter to continue it. My thought would be, let's just continue tonight until the 27th, which is
oh,
what you
I see
said.
what. So we're talking about I think we're talking about two different things. One is extending, continuing the public hearing. Another is extending the 180-day
Right.
period. And I'm confused.
Well
Which one are we
planned.
talking about?
Our next meeting is scheduled to be January 13th.
Yeah.
I understood you to say you don't think that's enough time for you to get this civil engineer peer review response that you need to. So
Yeah.
the next meeting would be January 27th, and the deadline to complete the hearing is sometime in February. I believe you said it was February 13th?
Yeah, let me just, I can actually give you an exact date.
Because I don't
Let me
have
just
that
look at
date,
my
but
file.
that's much too close to January 27th, so my thought is we need an extension of time beyond that date so that we can plan accordingly.
I just want to see what the date is, and Jasmine's really good about putting all the meeting dates
And
on her
You
calendar.
don't
So-
have to give us an extension for 4 months, obviously. But
Yeah,
I'm
so
not
the-
comfortable in having not having our next hearing date be less than 1
Okay.
month before the deadline.
Yeah, so it looks like we opened the hearing on August 26th, so it would be through somewhere around February 25th. So it's later in February than what I thought.
Okay.
So
Well, in
I
that
would,
case, then why don't we deal with it
let's
on the
talk about it on the 27th. And I think you're right. I think that I'm not sure how much we can accomplish because of the 2 holidays. So let's just shoot for the 27th for sewer update on, for civil update on where we are in the sewer testing, our working group talk. And maybe by then we'll even have the architectural peer review and we'll be able to turn that around as well. So.
Sounds good to me. Brian, Ryan, Stu, you all set with that?
Yeah, that's fine.
Yes.
Yes.
I
Okay.
just want to make sure Paul's okay with that too.
Yes, I'm fine with that.
Okay. If there's nothing else, the chair will entertain a motion to continue the public hearing to Tuesday, January 27th at 7 PM.
So moved.
Is there a second?
Seconded.
Aye, John Trefethan, vote in favor.
Hi, Brian Forrest, all vote in favor.
I, Ryan Sullivan, vote in favor.
I, Stuart Siegel, also vote in favor.
Excellent, thank you very much. This matter is continued then until January 27th at 7 PM. And
Thank you,
Thank you.
Mr. Chairman.
Thank you.
Happy holidays to everyone. Hope you all
Merry
are
Christmas and
healthy.
Happy New Year, yes.
Bye-bye.
Okay, item number 3 on the agenda is continuing our deliberations on 10-60 Main Street, Chapter 40B Comprehensive Permit. We closed the hearing back on, I believe it was November 25th. And we have been in deliberation on December 9th and again this evening. At our last meeting, Mr. Engler, the applicant's representative, had indicated he would be unable to attend tonight's meeting because of a very important family obligation, his mother's 80th birthday, and we certainly can appreciate that. But I thought there would be something the board could accomplish tonight by reviewing the most recent draft decision by Attorney Winter that was distributed, I believe, at the end of last week, and perhaps ask Brian if you could lead us through the changes in the decision, or the draft that you had made from the original draft to what we got late last week, so that we could have a discussion about that, and then also talk about the list of waivers and any revisions that had been made in that, if that's okay with my fellow board members.
Yep.
So it seemed like it would be a productive use of our time when the applicant was not going to be here to answer any questions we might have. Counsel.
Certainly. So, as the board will recall, we've exchanged a few drafts. I took the lead with Jasmine, and we prepared and circulated the initial draft That's been exchanged a couple of times now. Most recently, we had a robust discussion with the applicant's representative, Mr. Angler. We went over a great deal of the red lines that he had suggested and the reasons therefore. Following that discussion, I then integrated the board's instructions into this new draft that you have here before you. And as you'll recall, there were a couple of sort of TBD items, a few conditions, some wordsmithing issues to be resolved. And so this draft reflects my effort to address those. So the first addition or change since the last draft starts on page 11. You'll see there are 4 conditions there that are highlighted. Those were sort of referenced in the last discussion, but they hadn't been written. And so now they're written. I should add that I circulated this draft to the board, I believe, on the 18th. I simultaneously provided a copy to the applicant's representative, Mr. Angler. Just due to his schedule, he has not been able to review this and respond. So I don't have the benefit of any of their review. So this is just mine and mine alone at this point. So there are 3 conditions on page 11, 32, 33, 34, and 35. The first one concerns a pre-construction survey of the Mill Street Dam. Obviously the purpose of that survey is to ensure that no damage occurs as a result of construction, and that if it does, the applicant's responsible for remediating and repairing any damage. Condition 33 is drafted at least, talks about the ocean house and the barn structures. Again, requiring a pre-construction survey and obligating the applicant to address any damage that occurs as a result of construction. 34 is a financial contribution from the applicant, $10,000 to the town to assist the town in peer reviewing any activity with respect to the AUL and the RAM plan. As you recall, the environmental component of this was a big topic of the public hearing. So the activity and use limitation and the RAM plan, as the board knows, we don't have the expertise in-house to really liaison with the EPA and DEP with respect to those things. And while we may receive and review the correspondence, we don't have anybody who can translate it for us. And so this contribution is to assist the town in that process. 35 has to do with the original mill granite on the site and requiring the applicant to use best efforts to repurpose and utilize any original or salvaged mill granite at the site. So those are the new additions on page 11. I'm just gonna continue on. Page 14. You'll recall the board had a conversation with the applicant with respect to, a post-construction and occupancy traffic evaluation. And there was a question about, well, if there are any, modifications or improvements that are revealed as necessary as a result of that evaluation, the applicant should implement those. And address whatever traffic issues came up. And the applicant was willing to make a contribution and commit themselves to $25,000 to make those things happen. I had made a suggestion that we should go back and look and see what those things are, if they were known. So I reviewed the traffic reports, the peer reviews, and all that material to see if I could identify what those suggestions were that weren't already implemented. I didn't get a chance to contact the author of that peer review and see what their thoughts were, but I didn't see anything that was clearly defined as a task item for post-occupancy in those reports. And so I've left it as a one-time payment of $25,000 to implement, any post-occupancy improvements that are needed. But between now and the next meeting, I will circle back with the peer reviewer and see if that needs any refinement. So that's an addition on page 14. There were some other just, typographical and clerical things, but I just accepted those changes. I didn't think they warranted a discussion before the board. The next thing I wanted to point out is the waivers list. This is kind of the last exhibit in this package. And you'll see, as we discussed last time, there are 4 columns. The local regulations being on the left, the next one over to the right being the requirement itself, the third being what the applicant proposed, and the fourth being the zoning board's decision. So for a number of these things, the board voted during its straw poll to grant the waiver subject to compliance with the site plans as approved by the board. So for example, the height, the applicant asked for a waiver, but obviously that's not a waiver to 400 feet. That's just a waiver so that they can actually construct the approved plans. And so the board's decision reflects that. And there are a couple here that I just wanted to point out to the board because a lot of these are very sort of general. They're very customary in any 40B. But when you get to, and these aren't, there's no page numbers here, but if you get to page, number 23, this is a little bit more complex in terms of how we handled it. So there are specific provisions in the town of Ashland, just chapter 247 of your bylaws, and that's stormwater management and illicit discharges and connections. And after discussing this extensively with the applicant, what we identified was that the applicant was looking for waivers as to the procedures, but not as to the substantive requirements. Most of the substantive requirements the applicant has agreed to comply with. And so you'll see in the right-hand column, that's what's reflected in the language here, that the board is granting the waiver as to procedures and acknowledging that the zoning board is the local permitting authority, but that the project will comply with Mass DEP stormwater management regulations, and acknowledging that the applicant is filing a notice of intent with the Conservation Commission under the Mass Wetlands Protection Act. And it also makes a reference to the non-procedural substantive applicable requirements as set forth in Addendum 2. And so Addendum 2 is attached. So there are 2 addendums. And the second one is a copy of the bylaw, section 247, and it includes all the language that they're going to comply with and strikeouts in the instances where the applicant is suggesting that the board should grant a waiver. And so just to be clear for members of the board and anyone listening at home, Addendum 2 is essentially the bylaw, and the applicant is agreeing to comply with it, but for the strikeouts that you see here. So that is waiver number 23. If I just continue forward a little bit, there are 1 or 2 others. If you get to request number 38, this is another stormwater provision. It's chapter 343 of the town's bylaws. And again, the board's draft decision here, as I've written it, grants the waiver as to procedures only. It acknowledges that the applicant and the project will comply with DEP stormwater management regulations, and all of that is set forth in Addendum 3. So you'll see there's a third addendum. And again, it goes through all the requirements of Chapter 343, engineering and consultant reviews, submission of application, application form, application contents, stormwater management plan requirements, and so on and so forth. O&M, operation, management plan and contents, changes, post-development, stormwater management criteria, and project completion criteria. And so those are all included in this decision. There are some strikeouts in there for things that the applicant is asking this board to waive as either procedural or redundant, considering that this board is sort of standing in those shoes and there's going to be a separate application. So that's all attached here in this draft. And I think I might have accidentally skipped over one. And I believe that was the design review. Yes, excuse me, it's number 14, request number 14, building design standards. And it says it's granted subject to material compliance with the plans and the approved final site plans as outlined in the decision and as set forth in addendum 1. And then you'll see addendum 1 is a list of provisions and requirements related to design review. And so the reason why I wanted to spend a little time just sort of detailing that, and thanks for bearing with me, is, you know, I've heard before the suggestion that a waiver is waiving the entire bylaw, and that by granting a waiver, it basically nullifies that bylaw. And so I thought it was important for the board to understand, and anyone listening as well, that the waiver is only granting very specific line item portions and not the whole bylaw and not the whole design review. And so those are captured in addendum 1, addendum 2, and addendum 3. And those are literally attached to the decision for all to see. So I just wanted to spend a little extra time on that. And so that's it. And so please let me know if you have any questions, comments, or concerns. I expect when Mr. Angler returns, he'll have some additional revisions and comments, and I will solicit some additional comments from the traffic peer reviewer to see if I could narrow some things down on that one item. And those are the outstandings.
I'm sure the board members are going to have some questions. I know I have just a couple, so why don't I start? With respect to the decision, setting the waivers aside for the moment, we had a special meeting where we had representatives of the DEP and Environmental Protection Agency talking about the plume, and the authority for dealing with all of that is with the governmental agencies and not with the Zoning Board of Appeals. Were any of the conditions placed on the applicant in the comprehensive permit giving the ZBA not authority over that, but knowledge or information about the various testing and whatnot that's going to have to go forward as this project goes forward, if it's going to be approved by the governmental entities? Because I think there was some concern that the town was going to be totally uninformed on all of this, and how are we going to know what's going on? Do any of the conditions in the decision affect that?
So yes, as you pointed out, this board, and in fact, really no jurisdiction in town has the authority of the EPA and DEP with respect to those items. But there are several provisions in here in the comprehensive permit that touch upon that. One is there's always an obligation that the applicant comply with all federal and state requirements, and that includes permitting as well. So that obligation is reflected in the decision. The second one is communication. I include a condition in this decision and all decisions that the applicant copy us on all substantive communications with any regulatory agency or other state agency. Obviously, with respect to the things that are sort of the core of the comprehensive permit, you know, mass housing, EOHLC, those agencies, we need to be copied on that. But it also includes any correspondence with any other agency. That would include the DEP and EPA. So obviously not, you know, administrative things, but substantive communications so that we're aware of them. We have an opportunity as a town to comment if we wish to. and also to be transparent with the information we receive. So that is in here. And then the last one that I want to point out is that the applicant has agreed to give us a financial contribution so that we can engage someone to assist us with that entire process. And so to the extent we get, detailed engineering and scientific materials that we don't have the staff to even to review, we would have the funds to pay someone to review that for us.
Okay. Brian, any questions?
Yes. On number 23, that zoning board's decision says the project shall comply with DP, and the applicant shall also apply for a notice of intent with the Conservation Commission under the Mass WPA. Is that our local Conservation Commission that they're applying that with?
It is, and the applicant has stated this several times during the public hearing that they will apply to the
Yep.
Ashland Conservation Commission. The difference is when they apply, they're applying under the state act.
Okay.
This board is administering the local bylaw. And that's why, you'll recall, we had a conversation, we spoke with Becca and solicited some information from the Conservation Commission as well as its agent, so that we could incorporate those suggestions under the bylaw here. But we don't have any powers under the state act. And so the applicant will be filing a notice of intent under the state act, which will undergo a public hearing before the Ashland Conservation Commission.
All right, so those guys on the commission are being included.
Yes, they will get that.
Great.
I know it's off topic, but 61 Waverly is already underway before the
I was
commission.
just going to say that
Yep.
they've already filed,
That's right, and I think they've
had at
had
least, I think, 2 hearings.
at least 2 so far, and the third is coming up in January, I believe.
All right.
So 1060 Main will follow the same process. They'll be in front of the commission.
All right, and then on addendum 2, under the application, there's a strikeout, and so lies with the requirements set forth here in the regulation. So that's just saying that it's going to apply, but at the state level, not the local level? Is that what I'm reading?
Can you point me to the one you're looking at?
Addendum 2, the paragraph in application, the strikeout, says that complies with the requirements set forth herein in the regulations adopted pursuant to this bylaw. So is that what is that taking away?
So you'll see that the word bylaw has a strikeout above that as well. Because the board is being asked to waive full compliance with the bylaw, the applicant is going to strike references
To the bylaw.
to the bylaw,
Okay.
right? Because this now becomes the law of the project. And so that's why we repeated the entire thing in addendum 2, so that you wouldn't have to look at this and then go on the Ashland website and then try to figure out which parts survived.
Okay. And then going back to the decision for the application, the 32 and 33 says the applicant's going to undertake a pre-construction survey of the Mill Street Dam. So who actually does that? Like, does Jeff go out and say it looks good now, and after the blasting it looks good again, or how does that work?
So it typically proceeds the same way we've done engineering review during the public hearing.
Okay.
And so keep in mind, they fund peer review throughout the construction of the project as well.
Oh, okay.
And so they would go out and do it in the first instance, and they would provide the results of that to us. And we would put eyes on it with our peers and staff. And if we have any questions, comments, or criticisms, we would provide those then. And the same thing would happen on the back end.
Okay, so it's both sides look at it before and after?
Yes.
Okay, and that's with the Ocean House as well?
Yep,
Okay,
that's right.
all right. It's just a little, I didn't understand, so it seemed vague, like, who looks at it,
Yeah, so it's their, right, it's their obligation to go out and do it. But anything that they do has to be submitted to us in writing, and we receive that and get a chance to review it and critique it if necessary, and then provide that feedback.
Okay.
So on both ends.
Thank you, Attorney Winters, yeah, Winter, sorry. That's it for me for questions.
Brian, questions?
Yeah, I have two. First goes back to following up on the question you had, John, which was with respect to the funding that's being provided to have somebody representing the town to look at some of the more technical issues that might come up that we get copied on with the DEP and the EPA. Attorney Winton, how do we come up with that number? Was that just an approximation based on, prior instances where we've had such a consultant, or is that just the number they were willing to contribute? Just trying to get some gauge on that.
No, it's not based on a scope of services from any professional. It's based on the number that the applicant was willing to volunteer.
Okay, so, hypothetically, if there was more work to be done than those funds could pay for, we'd be left with either not having that review done, or the town would have to find somewhere in a line item budget to come up with the delta, right?
So that's right. If the funds are exhausted, then the town would have a choice to make, right? Either just not continue or find another way to fund it. I just want to point out, and I'm not trying to make the argument for the applicant, but this isn't something that a town normally peer reviews in a comprehensive permit setting to begin with, because it's not within the board's jurisdiction.
Yeah, I mean, there's a ton of eyes on this. I fully understand, but obviously, given the history and what this town's been through, I definitely understand why it is that the community has, an extra focus on these issues, and appreciate that they're willing to make that contribution. Just trying to get an idea of, how we came up with that number. So Thank you for that.
Understood.
My other question relates to in the waivers addenda 3, and specifically the strikeout that we find on the changes to operation and maintenance, which is on page 18. I'm sorry, it's under post-development stormwater management criteria. There's a strikeout there that begins with no untreated discharges. If this is inappropriate for this discussion, let me know, but I do recall a pretty extensive discussion about the stormwater runoff and how it will be treated with a system, but that the capacity for that system could at times be exceeded based on the level of rainfall. And for that reason, they weren't going to guarantee that there wouldn't be any untreated discharges. And they also, pointed out that, hey, what you have right now is completely untreated discharge coming off this property. So it's an improvement. I'm just looking for, maybe for my fellow board members, is that your memory of that discussion as well? Or am I misremembering that?
I will defer to your memory because I don't have a specific memory at this moment about that.
I'm in the same boat as John.
Okay, I'll try to go back to that meeting. I believe it was one of the ones in August, just to double check. But yeah,
For what it's worth, I do recall that, vaguely recall that. I should qualify, and I do remember discussing this, or the board discussing it with the applicant. And I think the applicant not only made that point, but also made the point that this was extensively and exhaustively peer reviewed, and that the peer reviewer was satisfied. And so keep in mind, it's not just what's here on the page, it's also all the changes that have been made to the plan to account for and accommodate all the comments that we received during peer review. So a lot of the system, stormwater, hard structure, soft structure, all that engineering that our peer reviewer required was done. And so it's now on the plan, and it's not written in this decision because it's, drawn. So I
understood.
think that's
appreciate that
response.
Excellent. Thank you. Yeah, I don't have any other specific questions at this point.
Okay.
I appreciate the effort on the redrafts.
Okay, thank you, Ryan. Stu, how about you?
Yes, I have one question with both these projects. Assuming this one gets approved, is there any provision that we have to make that these entities deliver periodically a report to the board of the progress they're making? Because it sounds like a lot of these waivers and such, or the material involved in this requires, the ZBA to be actively involved in this.
So the answer to that question is yes, but primarily it occurs through staff, town staff. So
Okay,
between now and sort of, I'll call it, the pre-construction phase. So there's a lot of things that the developer's gonna do, right? They've gotta finance it, and they've gotta finish up all of the other things that we don't see. And then when they're ready to build, there's a pre-construction meeting, there's all the pre-construction surveys that they have to do. There are, what's the word I wanna use? There are meetings that have to occur incrementally. And so all that information is going to be accumulated here. I mean, this is the repository for it. And so you can put on your agenda as often as you like an update on all of those things. And there are certain items that, the town staff might need direction on from time to time. So it's not unusual for those reports to come back with a question. How does the board wish to proceed, in light of, the situation that just arose? And so not only will you receive those written reports and staff updates, but there may be occasions for us all to sit down and have a conversation about what's going on over there. And so this board is always welcome to put it on its agenda, for those updates and for those discussions.
but is there,
Go ahead, Stu, sorry.
is there something that has to go in writing? In other words, if one of the projects says, I don't have time to get back to you on this, or, is there something that establishes the protocol that they're responsible for always communicating to us? And they have to follow through on that.
Yes, and in fact, I have put in these decisions something that I've been doing for years now, which is that the applicant has to designate a project liaison that has the responsibility to be a point of contact, not only for the town, but for the neighborhood at all times. And so we want to know that there's the person's name, a person's phone number, and the fact that they're going to pick up that phone when we call. And so it's more than just the technical folks reviewing and responding and putting boots on the ground over there. But we want basically a community liaison, so that, the public and town hall know exactly who to call when we need an answer.
And that was written into one of these provisions that is in in the document that we're reviewing now?
Yes. And considering it's, 40 pages, I can't give you the exact number right now.
Okay. But
when we
it's
meet
there.
again, I will highlight it. So I've written down all your questions. And when we come back, we're going to highlight all those provisions so that I can then point them out when we discuss it again.
Okay, thank you.
And Brian, there's also a statutory requirement that the applicant begin construction on the project within a certain period of time from the approval?
Right, the permit, and this is by regulation, the permit is only good for so long. And so the applicant either has to get the project underway within a period of time or come back here and request an extension.
And by underway, that means the start of construction or?
Yes, exercising the permit, right? It doesn't need to
and
be completed.
Is it a 2 or a 3 year period?
3,
3, okay.
my recollection.
Okay, any other questions from board members on what we've talked about this evening?
I don't have any.
Okay, not hearing anything from Ryan or Stu. I think we're good on that. Now, as I understand it, and as Brian has tried to educate me, because the hearing has been closed or we're in deliberations, we don't need a motion to continue this to the next hearing date, next meeting date, we just need to schedule it?
Yes, and just for Stu's benefit, it's condition number 47. I was able to find it. That's correct, so you don't need to vote to continue it to a date and time certain, the way you do a public hearing.
Okay.
It's just a regular business item now.
Okay, so it'll be on the agenda for
Yep.
our next meeting on January 15th. I'm sure, not the 15th.
27th, right?
Nope, we're gonna meet on the 13th.
Oh,
So
13th.
this
okay.
will give us something to do on the 13th. So we don't need a motion on that, so that's good, January 13th at 7 PM. Next item on the agenda, Jasmine, there are no meeting minutes? The agenda says December 9th, but I don't recall reviewing them.
No, unfortunately, those were not completed in time for
Okay, that's
tonight.
fine. I just wanted to make sure that that I wasn't overlooking something. Next item is staff updates and administrative matters. Do we have anything to report on that?
No, only that Mike Carter has been provided the updated stormwater for 55 West Union, so he is obviously aware of that and taking that into account in his review.
Okay, fine, excellent. Well, that being said, I guess we can entertain a motion to adjourn the meeting.
So moved.
And is there a second?
Seconded.
I, John Trefethan, vote in favor.
Aye, Brian Forrest, all vote in favor.
I, Ryan Sullivan, vote in favor.
I, Stuart Siegel, vote in favor.
Excellent. And wishing everybody a Merry Christmas, a Happy Hanukkah, a Merry Kwanzaa, and because we will not be meeting until after the first of the year, a Happy New Year.
Here, here.
Thank you, everybody.
Thank you.
WACA,
you.
thank you as well, and those happy wishes apply to you too.